Good morning, this is your Kelso Report for Monday, June 4th, and I'm your host, Clark Kelso. We begin with a Ninth Circuit case involving limitation of actions in an antitrust context. The plaintiff, a carbon fiber producer, sued a competitor in 2008 for injuries it allegedly suffered as a result of a carbon fiber price-fixing scheme began in 1992. To avoid the effect of the applicable 4-year statute of limitations, the plaintiff contended that the statute of limitations was tolled due to fraudulent concealment by the defendant until the plaintiff had completed its own internal investigation in February 2001. Well, unfortunately for the plaintiff, it had itself been subpoenaed by a federal grand jury in January 1999, along with other carbon fiber producers, as part of a federal investigation into industry-wide price fixing. Thus, the plaintiff was certainly aware, and likely even participated in, the alleged price-fixing scheme during the 1990s. In these circumstances, the way the calendar worked out, both the District Court and the Ninth Circuit determined that the plaintiff's claims were in fact time-barred. Our next case involves administrative law. Shortly after a Social Security disability hearing, and before the ALJ had issued his decision, an FBI agent told the ALJ ex parte that the petitioner was apparently faking his disability. The ALJ immediately sent a letter to the petitioner's lawyer disclosing the ex parte contact. The ALJ suggested that counsel could contact the FBI agent if he wished, though he did not represent that the agent had agreed to talk to counsel. Well, it's clear here that the ALJ mishandled matters. First, the judge should have refused to hear the ex parte communication. Ordinarily, if someone comes up to a judge and says, "Judge, that case you heard this morning," the judge should immediately respond, "Don't tell me anything about it. I can't listen to evidence out of court." Second, the ALJ compounded his error by noting in his decision that he did not give significant weight to the FBI agent's information. He didn't say he disregarded it or gave it no weight. So that's error number 2. Third, the ALJ refused the petitioner's request for an evidentiary hearing at which he could at least cross-examine the agent. Notwithstanding all of these errors, the Ninth Circuit ultimately concluded the error was harmless in light of significant other evidence in the record, demonstrating that the petitioner had in fact exaggerated his injuries significantly and had changed his story, destroying his credibility. Next, we have a long-standing gun case coming out of Alameda County. The Ninth Circuit in bank in Nordyke v. King hopefully has resolved a long-running dispute in Alameda County involving gun shows. Counsel for Alameda County gave the county's current official interpretation of its ordinance in light of recent U.S. Supreme Court opinions, conceding that the plaintiffs, when conducting a gun show, may offer firearms for sale with the requirement that when a firearm is not in the actual possession of the authorized participant, the firearm must be secured to prevent unauthorized use. Now, the county represents that a sturdy cable attaching the firearm to a fixture such as a table would be good enough. The county further represents that buyers may physically inspect properly secured firearms. Well, given all of that interpretation, the Ninth Circuit held that the ordinance now regulates the sale of firearms at plaintiffs' gun shows only minimally and only on county property. And the ordinance as interpreted does not violate the Second Amendment. So the county, by giving on quite a few items, appears to have satisfied the constitutional requirements. Next, we have an environmental protection case. The issue in Carrick Tribe of California versus United States Forest Service was whether the U.S. Forest Service must consult with appropriate federal wildlife agencies under Section 7 of the Endangered Species Act before allowing mining activities to proceed under notices of intent in critical habitat of a listed species. The in-bank panel held by a 7-4 vote that consultation was required because the Forest Service's decision not to reject 4 notices of intent to conduct mining in the Klamath National Forest was, quote, agency action, close quote, that on the record presented, quote, may affect, close quote, a listed species or its critical habitat, in this case the coho salmon, thereby establishing the statutory requirements for consultation. The dissenters objected that the majority had improperly converted lack of agency action, that is, the failure to reject the notices of intent, into agency action subject to the consultation requirement. Because the majority's decision substantially burdens a private party's statutory right to mine on federal lands in these cases, I think the Supreme Court might decide to take this case up for review and try to determine whether the failure to reject the notice of intent constitutes agency action. Now we turn to a loss of consortium case under California state law. This one is another opinion involving asbestos-related injuries and Hennessy Industries. This time, the 2nd District faced a loss of consortium claim involving asbestos-related injuries in Van Hooser versus Hennessy Industries. The first element of a loss of consortium cause of action is the existence of a marriage at the time of injury to the plaintiff's spouse. Well, as you know, with asbestos-related illnesses, as with other latent diseases, appreciable injury does not occur at the time of exposure, but often takes decades before disease is diagnosed or symptoms are discovered. Recognizing this clinical reality, the 2nd District held that the first element of a loss of consortium cause of action is satisfied if the plaintiff's marriage to the injured spouse predates discovery of symptoms or diagnosis of an asbestos-related disease, even if the marriage postdates the spouse's exposure to the asbestos that ultimately causes the injury. Seems to me an eminently reasonable interpretation of the law. That's it for today's Kelso Report. Have a great day in the law.